I believe, my lord, one installment has already been released.
One installment means it's applicable from 1st of April. So April's money has been disbursed.
No, no. Because the notification is issued
But
below.
I'll come back with better insight. I'll come
Because
back with insight.
applications are to be called
Yes,
for,
that-
it
that
has
has
to
been
be
received.
scrutinized, screened. There is a screening process. It will take time.
Yes.
How can it be done so soon?
But I'll take, my lord, better instruction and come back, my lord. I don't think that I should make any comment on that.
But then please do not distribute the money.
Huh?
How many candidates' jobs were set at naught by the order of the Supreme Court? Who will be the beneficiaries? The figure?
C and D.
And page 71,
Yes, ma'am.
the third recital
Yes, ma'am.
mentions about a similar incident in the past.
Yes.
What are such similar incidents in the past where the financial benefit has been granted
Well,
to?
there has been a lot of instances, may not be for relating to employment. To my knowledge, see, for example, my lord, puja donations.
No, those are separate.
Yes,
Those
no,
are
these
separate.
are because 282, my lord, the attention of the court has been drawn to 282. Therefore, my lord, I am saying, my lord, these are all, my lord, come, my lord, under different heads from the consolidated fund, and my lord, different separate account numbers are required to be, my lord, maintained. And there's another judgment where right now, my lord, I don't recall, where, my lord, our High Court has held in regard to the expenditure from the consolidated fund. It is not for a judicial review by a writ court. I'll get that judgment because I was possibly, my lord, addressing the division bench on that. In a PIL, my lord, that was held.
Regarding the
financial expenditure.
honorarium granted to the
Very many
Muslim,
was there. Very
to the
many was there.
Muslim priests or something.
Yes, yes, yes.
There is
No.
one order,
Yes, yes.
right? But tell me, so you are not aware as to why this 25,000
20
has
and 25
and
were
the assistance that you will be giving to these people, will these people give anything in return, or they'll sit at home and they'll earn the money?
my lord, here, my lord, because of, as the scheme says, because of sudden loss of livelihood.
That means somebody will stay at home and you will go on paying the money till the Supreme Court decides an issue.
But this
And
can-
how long will the issue be said to be pending before a Supreme Court? Because one after another review petitions will come. There will be no end. You cannot stop anybody from filing a review
that is for,
application.
my lord, the Supreme Court to consider how long, my lord, Supreme Court will entertain.
And no,
Supreme Court will
your
not
petition
entertain me
says,
also.
no, your petition says it will continue till the matter is pending.
No, still, my lord, this review applications, my lord,
So one after another review applications will come.
No, my lord, please have a look to, my lord.
Second paragraph, filed review petitions before the Supreme Court. Central School Service Commission has filed review petition. Right.
No, it's only, my lord, the state government, the first recital. Please have a look to page 70.
Yes.
The state government, along with the School Service Commission, has filed respective review petitions before the Supreme Court.
Yes.
Yes. So it is only, my lord, the review applications which has been filed by the state and, my lord, commission, which is taken note of in this scheme.
No, but then what will be your submission with regard to paying 20 or 25,000 rupees to a whole lot of candidates who are sitting at home and not doing any work? Public, you are spending public money for it.
Yes. Yes.
And to candidates whom the Supreme Court has specifically
Not to
used
prejudice
the-
of- may I say this? Yes, I got your lordship's point. My first response would be, my lord, that, my lord, at the instance of, my lord, the writ petitioners, my lord, with respect, my lord, kindly do not take me amiss. Possibly, my lord, this point cannot be raised by the petitioners. That if I am not getting, why is he getting?
No, he is not getting his waitlisted, no question of
Therefore,
it.
my lord, if he or the petitioners over here cannot get, then, my lord, the petitioners does not have a cause to pursue before this court.
So you want somebody who were there in the Supreme Court to come here and challenge this? Who could be the, according to you, the challengers to this
My
scheme?
lord, may I say this, my lord, today, my lord, we are concerned about the writ petitioners. But if the writ petitioners either have a right or they don't have a right. If they do not have a right, my lord, then whether tomorrow somebody will come or somebody comes at my liking is something different. if they do not have a right today, my lord, in my very respectful submission, my lord, this petition cannot be
Maintainable. All right.
entertained. Because, my lord, your lordships have held, my lord,
Yes, I follow.
mandamus is, my lord, for infringement
Anything
of an established right.
Anything in reply?
No, 1995. যেটা ও রিলাই করলো
99.
1999 No, the deepest of respect, my learned advocate general probably.
The first demurrer was locus standi. It is not a pill, it's a writ petition.
That this writ petition by a person who was a candidate, after cancellation of all appointment method, all persons come to the same footing. There you cannot make a classification. That's the first point Milord, for a writ petitioner, which comes under Article 14. I am not, therefore the locus standi petitioner Milord, cannot be questioned at all.
Very well.
Secondly, one important aspect which you wanted to raise kindly takes up 1999 5 SCC. I have not cited judgment, but if necessary, there are judgments, I will cite it. But let me rely on his own judgment, which is relied upon. First of all, this has no 141 application. Kindly first,
144.
no, 1999 5 Supreme Court case says page 733 does not decide any law which has binding nature to this court under Article 141. What does the court say? Let us see. May I just place it? Paragraph 4. We are rather concerned to note that the writ petition number such and such has been entertained by the Lucknow bench of the Allahabad High Court. That writ petition is directed, kindly see, against an auction sale of house number such and such, and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court has noticed in the interim order that auction was being conducted under the orders of this court, and the matter concerning auction of the house was pending in this court. Therefore, the question of amity of judicial discipline comes. In our case, this is a new cause of action. You prepare a scheme after the judgments have become a concluded effect. Mere filing of review application does not legally entitle somebody to say that the
List is pending.
only after the review notices are issued, and the lordship knows, as so from my experience I can tell you, the lordship, the Supreme Court review applications are not hard. This is decided by the honorable.
Correct. Kindly have a look at page para 46, page 60, 45 and 46.
মিস করেছি
টেন্টেড যারা তারা দেবেন
However, Miller, candidates who are already employed need not be asked to refund.
These are for the teachers. The scheme is for non-teaching staff.
না না স্যার এটা বলে দিন
ফটফট করছি
46 does not, Miller, make any distinction between group C, group D and teachers.
স্যার নট
আরে
স্পেসিফিক
কোচকে পড়তে দাও না, এত ছটফট করে কেন?
Those who are already employed need not be asked to refund.
Yes.
Right.
Yes.
So you are not giving money to the candidates who are already employed. You are giving money to the candidates who have been terminated.
No, no. But my submission is, Mr. Bhattacharya in reply, submitted that
Yes.
Supreme Court
Refund.
had directed refund.
Yes.
That, Miller,
But paragraph 45 says
no.
they should be required to refund any salaries received. Then
But 46, Miller, does not make any distinction between the C, D, or Miller teachers.
please,
Very well. You are
whatever the Supreme Court has said, the Supreme Court has said in the
Thank you.
order. Whatever.
But one more thing, Miller.
Yes.
Mr. Bhattacharya has submitted that filing of a review application does not mean that the Supreme Court is
In CC of the matter.
number one. Miller, the division bench has said that the Supreme Court is in CC over the matter.
Yes, yes, you've
And number two,
submitted that.
Miller, there is a judgment of Justice Rumapal. Miller, I don't remember, the page was 555. That's why I remember the page number. Where, Miller, in the context of a contempt application, Miller, our court held that once something is filed in the department, the court or the matter becomes subjudice before the court. Then, Miller, the court may allow it, may dismiss it, whatever it is. But, Miller, once it is filed in the department, the matter becomes subjudice. If required, I can give that
No,
judgment.
that
But
is-
over here, Miller, our division bench in the context of this matter has said
That
that it is
is
in
correct. That was in respect of limitation of contempt application. That since it is filed, limitation will not run.
yes, but so yes,
তো ওইটা ঠিক বলেছে, লিমিটেশন ছিল কন্টেম্পটে 1 বছরের মধ্যে অর্ডার ছিল বলে ফাইল করলে পরে ধরে।
and Miller, salary possibly not.
And whether similar type of schemes are extended or thought of by the state in respect of so many unemployed candidates?
No, see, my lord,
Only in respect of the candidate
unemployed,
orders
yes.
whose appointments have been set at
The
naught by the
Supreme Court, my lord,
Very
the
well.
Supreme Court can take care of that, my lord.
No, no, you are the state. You will take care. Supreme Court is not
But, my
framing
lord,
the
then, my
scheme.
lord, I have raised, my lord, a legal issue that when it is, my
Hmm.
lord, concerning the Supreme Court and in response to the
Yes,
submission
yes, I followed it.
that the Supreme Court